This is a fun event, a fun afternoon that we have planned for you guys. My name is Nate Krampe, for those of you who don't know me or have forgotten what I look like. I am a certified financial planner, the vice president here at Summit Investment Advisors, and today we're going to be talking about and giving you 5 key tools for your arsenal in wealth transfer, and specifically surrounding estate planning. So after today, you're going to have basically greater understanding as to how wealth transfer affects your assets, your wealth that you've done so well accumulating over the years, and how you can make sure that you do the wealth transfer properly so it goes to the intended people, places that you want to go to with the least amount of tax owed. So that's what we're going to be talking about tonight, and you're going to leave feeling nice and calm and cozy and all those niceties, and you're going to have a sense of peace with your wealth. Now, there's been a lot of studies on wealth management, wealth transfer, estate planning. One key study that I really enjoyed, though, is that your life is like a roll of toilet paper. It's long and useful, but with our help in estate planning, we're going to make sure that it never ends at an inopportune time. Let me introduce our speaker for this afternoon, Corey Westman. Corey is an attorney and shareholder of the Minneapolis law firm Erickson & Westman. He practices law exclusively in the area of estate planning, trust and estate administration, and business succession planning. He assists a wide range of clients with implementation of estate planning. For the clients who own small businesses, family cabins, or other unique assets, he helps these clients consider their options for efficient succession plans. Corey also assists families with tax, probate, and trust administration as well, following the death of loved ones. He obtained his undergraduate degree from Wheaton College in Illinois, where he was a second-team all-conference third baseman on the varsity baseball team. Corey completed a master's degree in economics from Iowa State University. Then he attended the University of St. Thomas School of Law, where he was a member of the first graduating class. Corey and his wife Heather now live in Minnetonka with their sons Owen, Brendan, and their daughter Kinsley. Let's make it a great afternoon. Please give a warm welcome to Corey.
Thank you. Thank you. Well, thank you. Can everybody hear me? Okay. Yeah, great. Well, thank you, Nate and Sean. I really appreciate the opportunity to come and talk about my practice area. As Nate said, this is our area of expertise. Our law firm is just down the road off 35W and Industrial Boulevard. And so my colleague Ryan Damoff and I are here frequently thanks to Sean and Nate and their team. We feel like we complement their service as well in terms of our estate planning expertise. So we do estate planning in the sense that we help our clients plan for that eventuality that the toilet paper runs out, that you have remaining assets. Here's a caption. I think it's if you don't have a printout there, I'll have it on the overhead, of course, here. But the caption says, "His will read as follows: being of sound mind and disposition, I blew it all." Right? So now that's when I meet with folks, I say plan A from an estate planning perspective is that you're able to use and enjoy your assets and give it away or spend it all, and as the saying goes, bounce your last check, right? That's plan A. This is all what we're going to talk about. Largely plan B in the sense that, as Nate said, you've worked hard to accumulate assets, or you've inherited assets, and you want to be a good steward of the assets and plan for I'll use the fancy phrase, disposition or the legal transfer of your assets at your death. So in terms of our presentation today, The general framework here is I want to leave some time at the end when we're done for questions, more specific questions. So I'm going to stick around afterwards for more specific questions. I hope that this is an interactive presentation and discussion. So as we go through each of these topics, please raise your hand and we can correspond or you can ask questions about the topic at issue. So we're going to talk about objectives, we're going to talk about tools, transfer of assets. We'll touch on a few special considerations, including I'll just touch on taxes briefly and see where that goes. So the common estate planning objectives for our clients really can be broken down really into two sets of decisions. Two sets of decisions. On the left-hand side there where we say pick your team, what we're talking about there is who is going to help you make decisions on your behalf when you're no longer able. Lawyers call these a fiduciary designation, or somebody who stands in your place to carry out your preferences. So I have 5 main roles here that we have serving on your behalf as part of a good estate plan. We'll talk about a trust in a minute. The person who's in charge of your trust would be your trustee, okay? The person in charge of your will is called your personal representative. Historically, that has been called your executor. So that's one and the same. If you have young children like I do, children who are under age 18, you need a guardian to be a stand-in parent. And then as we'll talk about shortly, a power of attorney and a healthcare agent are individuals, or at least positions to be filled by individuals for who's making decisions for you if during your lifetime you're not able to make your own decisions. So these are the folks that are sort of on your team. And then the other aspect of objectives is who gets stuff, right? Now, in my Plan B analogy, who gets your remaining assets? So many of us want to leave an inheritance to loved ones. With certain beneficiaries, you might want to control how and under what conditions they receive assets. So that's an important element. And then you might want to give specific items and or make charitable contributions. So I think this is a pretty good list of the overall set of objectives to why you should consider putting together an estate plan. Just to clarify, I think it's always helpful to clarify at the outset various terms that come up. So hopefully this will be helpful to you, if nothing else today, just to clarify a couple of terms that you may have heard of before, but I just want to specify for you so that this is helpful to you. 2 documents I mentioned a minute ago that are really only relevant during your lifetime are power of attorney and healthcare directive. These documents allow you to designate somebody as an alternate decision maker if you're not able to make your own decisions during your lifetime. Power of attorney is, fortunately, you don't have to name an attorney. We'd all be in trouble. It's just somebody who that you trust to make financial decisions for you during your lifetime. The healthcare directive, also known as a living will, allows you to designate, at the very least in my practice, I say at the very least you should name somebody to make decisions for you with regard to your health care. Okay? So those are 2 important documents that everybody I meet with in terms of a client engagement I want to have in place. After death, we want to make sure that you have something in place to direct the distribution of your assets. At the very least, it's a will to direct assets at your death. So will controls assets at death, and you, of course, during your lifetime make your own decisions, but the power of attorney the person named under the power of attorney controls assets during lifetime. I want to introduce a concept here now on the bottom here called a revocable trust. A revocable trust. If you've had family members do estate planning, or maybe if you've had your own estate plan done, you've had a conversation about a revocable living trust. The idea with a revocable living trust is that you can create a structure to minimize the hassle associated with the transfer of your assets and the management of your assets, both during your lifetime, more specifically in the event of your incapacity or not being able to make decisions, as well as at your death. So a revocable trust is merely a legal entity that you, as the creator of a trust, would wholly control. The term revocable comes from the fact that, among other attributes, you can revoke it in its entirety. You could say, I'm done with this, I'm just going to take my assets back. You're more likely to look at a trust and amend it or change it of this type. But the idea with a revocable trust is you've got your own legal entity that you're a beneficiary of, that you control, and that legally speaking now, it survives past your death. So the idea is that you've got a legal entity that you would transfer assets to, that you would control during your lifetime, and then during any period of your lifetime, if you're not in good health, or after your death, that you have a structure in place in terms of the management of those assets. I work with many clients who are in their 80s and 90s, and they've established a revocable trust, and they've named their adult children as the so-called trustee so that their adult children can manage their assets during lifetime. We've touched on this already a little bit. Two important documents, again, for estate planning. These are difficult topics to discuss, but as part of what I consider a good stewardship plan, a good comprehensive plan in terms of planning for the possibility that you're not able to make your own decisions, you really should consider having these documents in place. And then periodically review them and update them as your needs change and the individuals you've named, their needs change. So power of attorney allows you to name somebody to make financial decisions. It's durable in the sense that it lasts through any period in which you might be considered to be incapacitated by a medical professional. So even when you become incapacitated, the person or people that you've named there will continue to serve for you during that period of time. In the absence of a power of attorney, in most cases it would be necessary to have a family member go to court to have themselves appointed as what's called a conservator. So in essence, it's one of these an ounce of prevention's worth a pound of cure type of deal where a little bit of planning now avoids a lot of hassle at a later date. A healthcare directive names someone to make medical decisions, and it is triggered only when your presiding physician determines that you're no longer able to make your own decisions with regard to medical care. And again, it helps avoid what's called a guardianship, which is just a court-supervised appointment procedure in which somebody has to be appointed to make your health care decisions. You can name the same person in both of these capacities. So you recall I had 5 total team members earlier. In my case, I have my wife named as agent under all 5. And you likewise could do the same thing with a spouse. For a lot of my married clients, I recommend both a primary and a backup individual for each of these 5 positions. So you can name the same individual or different individuals on each of these designations. A revocable trust, I'm going to actually start on this side of the ledger here. A lot of our clients will have a revocable trust in place during their lifetime so that they're actually creating a revocable trust and then transferring the assets, certain assets like real estate or an investment or savings account, to their trust so that legally that trust is the owner. And in that case, for family members after the death of a loved one, there isn't, in 99 times out of 100, any court involvement. So it would be a matter of looking at the terms of the trust and then coordinating with the closer when you sell real estate or other third party, the custodian of investment accounts. So as I was saying here at the bottom, the last bullet point, the assets are distributed through the trust agreement without going through probate. And probate is, as we'll discuss here shortly, just the court-supervised process of transferring assets following the death of a loved one. A revocable trust would allow for the coordination of all that to occur through a trustee. If assets of a loved one are in their name and not passing by what we call a contract, I'll get to that in a second, then in fact the last will of the loved one is effective to direct where those assets go. So for example, if I have real estate or an investment account, then at my death, and if it's in my name, I pass away, my will would say my wife is the personal representative, is in charge of that, and the will would direct where those assets would go. Now, in this circumstance, where I die with an asset in my name, it is necessary to apply for what's called probate proceedings or to obtain what are called letters testamentary. It's just the court-supervised process of transferring assets following death. We're, of course, a law firm, and we help those families who are in that situation, and so we do that type of legal work in our firm to help our clients to transfer the assets out of the name of a deceased individual. So back to the question about whether and what you would need to do if you have a loved one who's passed away, if there's assets in one's individual name and not in a trust and not passing by what's called a beneficiary designation, which we'll get to in a second, then this process would need to be followed through the will. The revocable living trust, as I indicate, allows you to create an agreement that is fully amendable and revocable. During your lifetime, you control and maintain your assets. I tell our clients that you really don't see a day-to-day difference in terms of the way in which you own and control your assets during lifetime. If you become incapacitated, your trustee that you've named would take over and then administer those assets during your lifetime. The assets are used for your benefit, not the kids. We've got to carefully clarify that during lifetime, mom and dad are the beneficiaries. They are the ones who are using the assets, even though you may be named as the beneficiaries of the trust. Mind your P's and Q's because it's fully amendable and revocable and you can be revoked, right? So after death, whomever you've named as the successor trustee takes over management of the assets. The trustee whom you've named, I sometimes get some confused questions on this, is that the person that you've named as trustee doesn't have the legal right to do whatever they want to with the assets. They legally have to abide by the direction of the trust creator, even if they don't like it. All right, so now I've had conversations with clients who said, well, I'm going to name so-and-so as the trustee, but they're not going to like what I have to say, and I might say, well, you might consider naming somebody else, right? Because while they're legally obligated to do it, they might not be real exuberant about doing that, about following through with the wishes. One of the key elements of revocable trust planning is that it does allow for the family members to avoid so-called probate proceedings. So another way of thinking about that is just a means of speeding up the process of the transfer of assets to your intended beneficiaries following death. I'm going to take another look at how assets pass at death, just to kind of give you a big picture view of how your estate can be planned. Okay, so I hope this might be helpful as well. We talked about the different ways in which your assets can be directed. We're saying that at your death, your assets could pass through a will. You could create a trust. Let's say you don't do either one of those. Okay? Let's say you don't do either one of those and you die. Well, as is often stated, that I've heard, and of course I'm in the business, so my ears are open to this, but they say that the state has a will for you if you don't, right? And that's what we mean by intestate succession, is there's a default rule in place for what happens when you die without a will and a trust. I was in court on Monday of this week. I'm representing a personal representative who is working with some extended family members of a gentleman who died, having no parents, no kids, no really any relatives, but for extended one aunt and extended cousins that I think several of whom he never met. Okay, so that's an example of something that, I never met this gentleman during his lifetime, but he probably didn't necessarily want to have those individuals receive assets, and that's kind of a worst case scenario. So that's the state of Minnesota trying to guess on what your intentions are, okay, intestate succession. So even before you get to the idea of bidirection, what actually supersedes the bidirection is by contract. So if you've got an IRA here at Summit, or if you've got a 401k through work, or a life insurance policy, I'm hoping you would have associated with that what's called a beneficiary designation. And that beneficiary designation is telling the company with whom you have that account or the policy to say, if I die, here's how I want to have the assets distributed. I want to just emphasize the coordination as part of a good estate plan with number two, with number one. And that is to say, a good estate plan is not just a will or a trust, but it's working with an estate planning attorney and financial advisors to coordinate the things like, Sue, that you mentioned, retirement accounts or life insurance, the beneficiary designation of with those accounts with what you've said in the will and the trust. I mean, in my practice, have come across numerous instances, I'd like to think they're not my clients, but when folks have died, that what folks have said under their beneficiary designation is not what they've said under the will or the trust. So you want to make sure that that's consistent. So
does one outrank the other?
Yes. Yeah, the question is, does one outrank the other? And the answer is yes, the by contract outranks the bidirection. So in other words, if you've got a beneficiary designation in place, that overrules what you've said in your will. Yeah. 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 So this maybe might prompt you to go home tonight and check your beneficiary designations on on that. And my general rule of thumb, if you're married particularly, my assumption with most of my married clients, and this is where you can insert your favorite marriage joke, but if you're married, you're going to name your spouse first as your primary beneficiary. But even if you're married, you want to make sure that you have what's called the contingent or secondary beneficiary coordinated as well, just to make sure that that's correctly stated. One last category is by law, and that is to say if my wife and I jointly own, and with joint ownership with rights to survivorship, what that means is that if you put somebody on as a co-owner, then you die first, then the named co-owner becomes the new owner 100%, okay? The first reason I generally recommend against it is because Category 3 trumps 1. If you're creating that for convenience, as I say, we call these convenience accounts, you got to bear in mind that if you've got 2 or more kids and you put one of your kids on, that child becomes the 100% owner and they don't have to share the assets with their siblings, okay? So that's one reason that we don't recommend it. There is another tax reason to your good question about taxes. The transfer of the asset into a joint account doesn't immediately create any tax problems. However, if you die, and if this is an investment account, for example, if you die, you generally get, if your assets are just in your name or in your trust, what's called a step-up in cost basis. And what that means is any appreciation in the value of your investment account is wiped away for income tax planning purposes. In other words, your beneficiaries could immediately turn around and sell all the investments there and not pay any capital gains on the sale of that. However, if you've got an investment account and you put one of your kids on as the joint owners, they are not entitled to a full step-up in basis because they're considered to be one half the owner, and they're still alive. So from a tax planning perspective, especially if we're talking about an investment account, it's generally not advisable. The last reason why, in many cases, I recommend against joint ownership is when you put on somebody else, or somebody else on your account, or you essentially transfer assets to a joint account, you're taking their credit risk. In other words, if they get sued, you lose your assets. So, yes, ma'am.
So what do you use to give people access to money that might be needed?
Yes.
What would be?
The power of attorney. Doris's great question. What do you do? How do you go about making sure that your assets are accessible to others to make sure that bills can be paid, or following your death that the right people are in charge? And I will say the short answer to that question is a power of attorney during lifetime, and then either a will or a trust to make sure the right people are in charge of those assets at your death. My wife, if she were here, she would roll her eyes at my long-winded answer and say, just give a short answer, right? And the short answer is, in some cases, the joint ownership will work, right? So I get paid to be afraid of my own shadow, right? To look at all the risks, and I want to lay out the risks of each of these arrangements. This slide is picking up on something I've touched on already a few different times, which is just the process associated with how assets get from A to B when you die. If assets are in your name, I'll go back here. If assets are not in this category, if you die, and if you've got assets in this category, then they're automatically going to the new owner. If you've got assets in this category, the assets are going to go to who you are saying through the trust or the beneficiary designation. Okay? If the assets are not in either of these categories and they're in your name, then you have what's called an estate. And And an estate is directed by your will. Okay, so if going back to my earlier analogy, I pass away, just hypothetically speaking, let's say my home was not co-owned, but it was just in my name, then an estate is legally created at that point in time. Our court system, our legal system has a public policy in favor of making sure that the right people get your assets when you die. Folks come to me and say, why do we have to do probate? And say, I wasn't around when I made the rules. We just got to follow them. So there is some procedure in place to make sure that the right people get the assets. Probate is that process. And a lot of folks will come to me and say, I want to avoid probate because we've had some bad experiences. And a lot of times it has to do with the time that it takes for beneficiaries to get the assets.
Do you have a will or a trust, or do you sometimes have both?
Yeah, this is again where my wife would roll her eyes and say, give a straight answer. Let me say it this way. The question, if you didn't hear it, was do you have a will or a trust, or do you have both? And my answer is that if you have a trust-based plan, you'll have both. If you have a will-based plan, you'll have a will, okay? The idea with a revocable trust is that is essentially your will. Your revocable trust becomes your will. It says, I'm going to hold and control my assets during my lifetime, but if I die, here's who should be the beneficiary, and we're going to do so free of probate proceedings. Now, as much as I try, clients don't always listen to me. And so assets aren't necessarily transferred to a revocable trust in ownership during lifetime. And that occurs, what I just am describing now will occur, and that is to say if an asset is not in your trust, if you tried to do a revocable trust and you didn't transfer the ownership of certain assets to your trust during your lifetime, then that asset becomes part of your estate, okay? And then what needs to happen is this, which is probate. And in that case, for my clients who have a trust, we have a will that merely says, take the asset from my name, and at that point it's in your estate, and you put it in the trust. So you're kind of accomplishing after death what you had hoped to achieve during lifetime. So the terms of that trust would still be the focal point of your estate plan. It's just that you have to go through the probate process, okay? So to say this another way, the trust agreement, if you did a trust agreement, would control the direction and distribution of assets at death. If your asset is in the trust by the time of your death, you will avoid all that, okay? If you have a trust but you didn't put real estate or investment assets into the trust during your lifetime, your will would say, now take those assets and put them into the trust.
Oh, so our will should say that.
That's right, if you have a trust, okay? Now, if you have a will, you say, phooey on the trust, I just want to do a traditional will. Your will in that instance would say, give to my spouse, or give to my kids, or give to my charities, and this process would be followed at that point in time. A will goes through probate, a trust does not. So a will, let's say you decide to use a will for the transfer of your assets. It's the legal process in which a court formally recognizes your will. So you would approve the will, appoints a personal representative. As I mentioned earlier, that's historically your executor, and then oversees the collection and distribution of assets, and then approves what's called a final accounting. So the process in Minnesota actually is much more streamlined than other states. I'm told in California it can be a couple of years before beneficiaries can receive assets. Our court system is about 2 months behind to get a hearing in Minnesota, at least here in the metro, to get the appointment, to get somebody officially appointed as your executor, so then they can then turn around and sell real estate. So again, the worst I think that can be said for probate is just the time that it takes for beneficiaries to ultimately receive through the legal process, the assets. But again, the point of the will is to make sure that A, the right beneficiaries get the assets, and then B, the right person or people is in charge of that process.
Does it cost
Yeah.
the executor to be an executor? I mean, is
Great.
there costs associated that the executor would
Yeah.
know about? Or?
Yeah. The good question is, are there costs that the executor would need to know about? By law, whomever you name as executor is not required to pay anything personally, okay? So your personal representative doesn't or shouldn't take on any personal liability. The law is set up so that your remaining assets are used to pay for the expenses of administering the estate. Yes, probate is expensive. I would imagine $3,000 to $5,000 in terms of costs following death, but those assets will ultimately come from the deceased individual's assets, not the personal representative's assets. So in naming a personal representative, you're not asking them to pay for your expenses. It's very important. In many cases, our clients will request that the personal representative be paid for their time. And so that's a very common provision that a court would approve. In many cases, our clients name one or more of their children as personal representatives, in which case, in most of those cases, the personal representative doesn't take a fee because they're a beneficiary anyway. So no expense should come out of the personal representative's pocket, and the personal representative should be paid, particularly if they're not a beneficiary. The transfer of assets. We spoke a little bit about a trust already, and probate. The assets in a trust, the assets that are transferred to a trust during lifetime do not need to go through the probate process. So a lot of the clients that I'm working with are creating revocable trusts to transfer the ownership of their assets to their trust to put the assets essentially in the right-hand side of the ledger, thereby sort of speeding up the process in the event of their death. The assets that are generally considered to be subject to probate are, generally speaking, not retirement accounts and life insurance policies, because I mentioned earlier those assets pass by beneficiary designation. And then we were talking about a transfer on death designation with a bank. If that's in place, that won't go through the probate process. Jointly held assets, what I call the convenience accounts, will automatically pass to the surviving owner. Anything that's not sort of on the right-hand column here then becomes a probate asset. Yes, sir. Yes, the question is, can you, with real estate, put a transfer on death deed, as it's called? It's comparable to a POD account. Yes, under relatively new Minnesota law, you can create a transfer on death deed to name your children as the owners in the event of your death. So that's essentially a way of putting real estate here kind of as part of a beneficiary designation in that scenario. Mm-hmm. Yeah, so probate assets that I find most frequently come up are investment accounts, bank accounts, or other assets held in the decedent's sole name. Just the probate process, what's involved with the probate process, somebody has to be appointed as the personal representative. They have to gather assets, have to understand what the tax situation is for the family, determine whether any claimants coming forward in terms of the fact that the deceased family member owed somebody money, to determine whether or not those claims are valid. and then distribute or pay debts and expenses, distribute remaining assets, and then prepare what's called the final accounting, which is just the financial statement for the family, and then close it out. I often tell our clients when they're going through the planning process that the key in designating a personal representative doing all these steps, the key is not whether the personal representative has a law degree or is an accountant. In fact, some of my worst horror stories are the clients of mine who are attorneys. They know everything and get out ahead of us. But who will take good advice and seek counsel. So, working with folks at Summit when it comes to investments, working with law firms to help them through that process. I always want to manage expectations for our clients in terms of who they name. The key, again, is somebody trustworthy, to name somebody trustworthy and who will make good decisions on who they turn to get advice. So you shouldn't expect the person that you name to know all this. You should just feel confident that they can find some good advice.
Are they legally bound at the time of your death to represent you?
Yeah, good question.
You say that about trust, then. I thought you said that they were legally bound to carry it out. How about
Yeah, well, better stated, if they choose to carry out their appointment, they can't do what they want. They don't have to serve. Okay, so Ray's good question is if you appoint somebody or name somebody into the document, do they have to serve? And no, they don't. Okay, they can decide that they don't want to serve. Okay, well then whoever you've named as the backup. Okay, yeah, you have a backup. Right. Or you not only should have a backup, but you might consult with who you were thinking about naming, just make sure they'd be willing to do it. Because if you name somebody who's not willing to do it, that doesn't do you a whole lot of good.
Think about the scenario where they said they wouldn't when the time comes.
Yeah. Right. Yeah. Yep. So yeah, those are great points, and that's part of what I call, ongoing estate planning. You're not done until you're dead type of a deal. Is just periodically reviewing who you've named, making sure that they're still in a position to be able to help. And I've worked with some folks recently where we changed who has been named because so-and-so is just too busy or not in a position to be able to handle that. So those are the sorts of things that I'd encourage folks who have an estate plan in place to periodically review and consider. I get questions a lot whether folks should do a will versus a trust. So the good question earlier about a will plan or a trust-based plan. A trust-based plan is usually more expensive in terms of working with a firm like ours because you need to not only create a trust, but you actually need to transfer the ownership of certain of your assets to your trust in order for the planning to be really worthwhile. As I indicated, the trust would control only those assets that are owned by it at the time of your death. So in order for a trust plan to be really worthwhile, you need to make sure that certain of your assets are owned by the trust by the time of your death. So the trust administration, just to discuss the difference between a will and a trust, I think sometimes it's helpful to understand how assets would pass at death. If you've got a will, then you would go through the probate process, which again in Minnesota is not all that bad. It's not changing who the beneficiaries are, it's just the process. If you've got assets in trust, then you avoid that, avoid probate, and you also have some management of incapacity situation. Yes, sir?
So when you're transferring things into a trust, say I go to you tomorrow and set up a trust, would that be like all your cars?
Yeah.
Take title and transfer them into the name of the trust?
Yeah.
So do you have to pay transfer fees?
Yeah, No, the short answer is no. Only certain assets that would trigger probate proceedings should be transferred to your trust at your death. A car is a great question, a great example of something you'd have no reason to know, that it's generally pretty easy, in Minnesota it's very easy, to transfer the title
Not anymore.
out of the... transfer the title of assets out of the name of the deceased individual with an affidavit. So no, when all of our clients who do a trust, I don't recommend you transfer a vehicle into your trust.
You don't.
No. But with regard to other assets, so for example, real estate, an investment account, savings account, if you've got real estate, particularly out-of-state real estate is a big issue for a lot of our clients. If you've got multiple homes, make sure that each of those parcels are in your trust. But precisely to your point, when I meet a new client, I want to know where they have assets, from automobiles to bank accounts to real estate, so that we have a plan, hence the state plan, for each of their assets to minimize the hassle. Going back to this issue here, what I meant to say, it's not real estate per se, or whether it's liquid. The question is, how is it owned? So if real estate, for example, is jointly owned, then there is no probate at death, because the surviving owner just becomes the sole 100% owner. I want to touch on a couple of just strategies to think about. I hope this might be useful to you. It won't be applicable to all of us, but I just want to mention it in passing. If you can read the cartoon, says, "Everything I have, son, I have because your grandfather left it to me. I see now that was a bad thing." So the issue that I want to touch on is how do you make provision for somebody in which you need to control how they benefit from the assets, okay? This is my colleague's little son, and since he put together these slides, he gets to show his beneficiaries, right? Last year when I did this presentation, I got to show off my beneficiaries, so he gets to show off his, as the saying goes. But clearly in his case, he's got a son who needs some management through no fault of his own, just youth, right? So same thing, I've got 3 young kids, and I've got a structure in place. I generally call these testamentary trusts to distinguish from the revocable trust that we've spent our time talking about. A testamentary trust being a structure that's implemented by reason of your documents that says, when I die, my assets are to be administered for my kids, okay? So the idea there is that you're naming a trustee to manage the assets for the benefit of children or grandchildren, for their benefit. I've been working with clients who have adult children who are going through a divorce, okay? So we're implementing a structure for them in which there is a testamentary trust structure created at their death so that that adult child can benefit from the assets, but there's a trust structure so that the divorcing spouse can't make a claim on the inherited assets. Okay, so the assets that are in a trust like this are protected under Minnesota law in the event of a divorce of the beneficiary, or even the beneficiaries having creditor problems. So in my case and in my colleague's case, just with young kids, not wanting to put the money in the hands of, say, an 18-year-old kid is wise. I say the only people who benefit from that are the boyfriend's rock band, right? So there's reason to do that for the kind of the spendthrift issues or just poor decision making, but there's also the benefit of protecting in the event of a bad event, like a divorce or the child's bankruptcy, or frankly, even the child's death. So if the child dies before receiving their inheritance, you can have a structure in place to say now it's going to their kids, that is to say your grandchildren.
That's separate though from everything else?
No, that's a great question. I'm sorry, for Debbie. The idea would be with this testamentary trust structure is that you would have a plan in place under either your will or your revocable trust. So remember, it's either your will or your revocable trust are the two sort of legal ways that you go about doing your estate plan. Regardless of that decision, you could, as part of that, as part of the estate plan, have what I'm calling a testamentary trust implemented for children or grandchildren or nieces or nephews to say, I want the money managed or the assets managed in a certain fashion. So again, that's what I call a testamentary trust, and a testamentary trust can be implemented under either a will, if it's your standalone estate plan, or a revocable trust. Yes, ma'am.
We have 3 daughters, so that if we die, we wouldn't want the money necessarily to go to our son-in-law if something happens to one of our children.
Right.
So is that what you're saying?
Yeah.
That to just go to our grandchildren and avoid the son?
Right. So it's such a great point. I'm glad you brought that up. The question, there's a trade-off, right? There's no silver bullet in life, right? The difficulty here is that there's a trade-off, and you should know that if you name your daughters, in your case, as sort of the outright beneficiaries under your will, your trust, no strings attached, they, of course, then can do whatever they want to with their assets, including giving them to their husbands.
Or do
Okay.
they have to take that step to give it to their husband, or is their husband automatically eligible for half of it?
No, on having to. Sue's question is, do they have to?
Just because they're married?
Well, no, they don't have to take assets out. And so this is going to be a long-winded answer, okay? Take assets. So if they receive assets, okay, then we're talking about a couple different risks here, and I'm going to be very careful about the different risks that we're talking about, okay? This can get complicated. If we're talking about death, generally speaking, the husband has what's called an elective share to receive those assets. So if you have a traditional plan that you say, my kids get the assets if they survive me, and you don't have a testamentary trust structure in place, when your daughter dies, that husband gets at least half the assets, okay, through what's called the spousal elective share. That's in the event of a death. Yep.
You don't get the whole thing, you get this half of it?
Well, at the very least, okay, it's difficult because it's very, very factually specific. And so if there are other attorneys were here, they'd say, go see your attorney. Okay, so I'm doing you a disservice perhaps to try to answer this question, okay? But it would depend upon the estate plan of your daughters, okay? So if your daughters have a will in place that says, give it to my husband, then that's what it is, okay? If your daughters say, give it all to our kids, by reason of Minnesota law, in the absence of a prenuptial agreement, the husband could claim a half. Okay, I'm skipping ahead one step. Okay, now back to the other bad event, Sue, that you mentioned. What about divorce? Okay, if your daughter receives all those assets, and again, no strings attached, I'm not, in this hypothetical, I'm not referring to a testamentary trust structure, okay, just no strings attached. If they hold, Sue, to your good point, if they don't put it into a joint account with their soon-to-be ex-husband, and then they get divorced, the divorce attorney representing your daughter would say, she got this from mom and dad. It's considered to be a non-marital asset, and it's not subject to division, okay? But I've been practicing long enough to know that that's generally not done, okay? So the honey, don't you love me plan is, we put it into joint accounts. Yeah?
I've heard several times where an older will is out of date or obsolete. What's the story on that?
Well, So that you've been told your will is obsolete or out of date?
Yeah, older will is out of date, like
Yeah.
30 years ago.
Yeah, no, that's not true.
Okay.
It may not be wise, or it may not be consistent with what you want, but just the passage of time doesn't negate the validity of a will, right? Yeah, okay. Yeah, yeah, yeah.
Is there an average price of a trust, like 700 to 7,000?
Yeah, the average price of a trust, at least in our firm, is somewhere between $1,000 to $2,500 in terms of a trust. Just depends on the number of assets, actually. It's not so much the total value of your assets, it's the number of your assets, because it takes some time to retitle assets into the trust.
So what generally is a will?
It's usually about $400 or $500 less. So it's a little about, I generally estimate about $400 or $500 more for a trust plan and than a will plan. Yeah. Yes, Bob?
I just want to clarify on the transfer to children. We have a daughter and son that we specify that in the event of their death, get a hospice spouse. Now, I don't know if I understood that.
Yeah, that's a great point. Let me carefully clarify that point. Bob asked that, or pointed out that under his estate plan, he's saying if one of his children doesn't survive, then it goes to the kids, okay? And here's where the order of deaths matter, okay? So if your kids die before you, that provision would apply. In other words, your child predeceasing is the legal term for it, dying before you, then the will would say in that event it's not going to the daughter or son-in-law, it's going to the grandkids. However, in the hypothetical we were talking about before, there you die first, your assets go to your kids, then the question becomes what happens when they die? And that's where I'm saying it's up to their estate plan. Yeah. So all of that is background to say, well, what can we do? Okay, what can we do? And what I'm saying is a testamentary trust is a legal entity that comes out of your will or your trust that says there's going to be some ongoing management. There are some strings attached here. So let's say there's $200,000 that goes to a particular child when you die, and you've got provisions that say, well, give that child $20,000 a year. Okay? So the trust structure is a means to control the 180, the other 180, so that if that child subsequently dies or subsequently divorces, you've got a legal wrapper around that, in my hypothetical 180, to protect against that bad event. So it's sort of controlling or protecting for certain post-death events that may occur. And again, it's counterintuitive because you're creating a structure that, as some of my clients would say, I'm controlling from the grave. And I say, you absolutely are. You're controlling from the grave. So
So I don't understand where, so there's 180 left because the child died. Where does that $180?
yeah, okay, I'm sorry. Let me go back and give a better explanation. Just of my analogy. I'm just coming up with some numbers,
No, I
right?
know.
Yeah. So let's say you've passed away, and the share for your child is $200,000. Okay, and this is under the scenario again of what I'm calling a testamentary trust. Okay, so initially that testamentary trust is funded with, or is created with, $200,000. And let's just say hypothetically that the terms of that trust, and that's governed by your will or your trust, say give them $20,000 a year. Okay. So that the other $180,000 is retained for years 2 and following in a separate account, whether it's Summit or somewhere else, in the name of this trust. And what I'm saying is that $180,000 to address those concerns that we've talked about, death and divorce in particular, is protected in one of those bad events. So that your trust or will that you signed way back many years previous in 2018 controls what would happen to that child's inheritance in the event of a death or divorce.
Because of what you said.
That's right.
What happens to this money if my daughter dies?
That's right. That's right. You're controlling from the grave. That's right. You have to have it in place before you die. That's right.
So,
Yes, go ahead.
so all your assets should still stay in that revocable trust?
That's the idea.
Your dad.
Well, legally speaking, the question is, all the assets stay in the revocable trust. This is where, again, my wife rolls her eyes and says that it can't be so simple. You can think of it that way, although the IRS doesn't think of it that way, okay? During your lifetime, the relevant taxpayer through your revocable trust is you. You have the pleasure of paying income taxes on that. But after you pass away, every situation is different. Let's say you just have one beneficiary. Then essentially your revocable trust becomes the testamentary trust. All remaining assets go from your control under your Social Security number to a new tax ID number that's assigned after your death. But you're essentially right. Then in that situation, the testamentary trust or the provisions that you have in place for children or grandchildren would apply at that point in time. That's right. That's right. Now, the only reason why I'm hesitating on the answer is because in my case, I've got 3 beneficiaries. Yeah, right, right. Yeah. Okay, I'm sorry, Karen. Yep.
I have my retirement accounts kind of scattered. I've worked for a number of entities in at least a couple states. So if I'm thinking of doing a trust and there's a cost for transferring those assets, might it be better to do some consolidation first?
Yeah. Yeah, Karen raises the question of cost and trust planning. I generally encourage our clients to consolidate their accounts. I mean, I just think that's the best, one of the best, frankly, non-legal ways of becoming more efficient, not only for yourself, but even in the event of death. I mean, the number of accounts for our client families is closely related to how expensive estate administration is. So I completely agree with that comment. Yeah. Just in terms of planning process, our firm works with a wide variety of clients, and we'd be glad to meet with you on an individual basis. This meeting, or our presentation here, is intended to give you a broad overview. It is hard, as the questions have shown today, to touch on each of the unique situations that you're each in. Part of the engagement process with our clients is to educate you on the issues of particular relevance. So, for example, estate planners used to go around town and talk about federal estate taxes. As you may be aware, as part of the changes in the tax code right around the new year, the so-called exemption amount, or the amount that you can pass free of federal estate taxes, is now $11.5 million per person. So most of us, especially if you're married, you have the right to give $23 million away free of federal estate taxes. So what used to be an issue in estate planning is no longer an issue for most of us. And that's kind of my point here, is to say there's only so far, presentations like this can go in terms of educating you on what's relevant for your situation. So that's where, you don't know what you don't know. And part of an engagement with a professional is to understand what is relevant to you in your situation. So, but every plan should have some documents, as we talked about. And then we believe in the value of periodic review. And certainly periodically reviewing. We talked about beneficiary designations, making sure that those are consistent, peace of mind being key. I had a couple clients today, as a matter of fact, where the life insurance companies don't like me because our paralegals at our firm keep pestering them to confirm beneficiary designations have been changed to do those things. So that's really part of a good estate plan, is kind of taking it upon yourself and hiring folks as necessary to get it done. So Ryan Damhoff, who is my colleague, he was here. We had a 2 o'clock presentation that Sean and Nate allowed us to have. He does a lot of planning as well. I do planning, and we'd love to meet with you on an individual basis to work out your, to address your particular situation. Well, thank you all for coming and for participating. I really appreciate your great questions. You've got my contact information, and I'll stick around here for more questions at the end. So thank you.